Good afternoon. Thank you all for joining. We're going to wait a few moments to allow additional people to join the webinar, so we will start shortly. So you'll just see Galina and I, who are both visions in green today, um, for a couple of moments. Right, just for everybody who's just joined, we're just going to give it another minute or so before we start, just because it always takes a little bit of time. Thank you all on what looks like it's quite a lovely evening for joining us for this, the last in our public inquiries online seminar session. Right, it's now 2 minutes past. And as I am a stickler for promptness, we are now going to start. I'm sure there's a couple of minutes worth of introductions. Hello, welcome to this, the last session in our inquiry law webinar series on challenging and challenge proofing inquiries. We're delighted to see so many of you joining the session today, and we hope that you're going to find it informative and maybe just a tiny bit enjoyable. My name's Fiona Scolding, and I'm the chair of the session today, along with speaking. I am quite literally writing the theme tune and singing the theme tune, but I am joined in my theme tune singing and by Galina Ward Casey. We do not have Miss Karine Patry Casey. Unfortunately, for reasons beyond her control, she's no longer able to join us. But I just thought I'd mention a few housekeeping points. Firstly, your microphones are all automatically muted, so you don't need to adjust any settings. Secondly, we very much welcome questions. Please put them via the Q&A box, at which you will find either at the top or at the bottom of your screen. If you'd like to remain anonymous, and we know some of you might wish to do so, please do just tick that box. We'll endeavour to try and answer as many questions. So I think we're aiming to talk between the two of us for about 45 minutes and then allow sufficient time. The webinar is going to be recorded. You'll receive a link to the presentations and the recording shortly. And also, as there are 3 in this series, we will ask Hilary, our marketing manager, who does such an excellent job, to link all 3 of those, so that for those of you who may well have missed the previous 2, which is a cumulative source of information, if your connection's lost at any point, just pop back in. So we're going to be talking about a variety of different things today. I'm going to speak first, and then Galina's going to speak second. My talk is going to be about, and next slide, please, is going to be about challenging notices issued under Section 21 of the Inquiries Act 2005. What happens if you don't comply with Section 21 of the Inquiries Act? Issues around contempt of court if you don't comply, and also some discussion about warning letters, which again, I will explain what those are. So those are the 4 things I am going to be discussing today. Galina will then be discussing should you judicially review an inquiry, what the process is for doing that, and whether it's basically a good idea or not a good idea. So we're hoping we can provide you with some practical hints and tips, as well as filling you in on the case law such as there is. This isn't an area which is overburdened with jurisprudence, if I put it that way. So a lot of it is about exercising kind of common sense and thinking about principles when you're looking at the issues in dispute. I'm a barrister in independent practice at Landmark. I have had the fortune, or maybe misfortune, to be involved in public inquiries now for the past 8 years. And I'm currently involved in the COVID inquiry, the Lampard inquiry, the Thirlwell inquiry, and I'm possibly about to be involved in the Nottingham inquiry. Accompanying me today is Galina Ward-Casey, who also has had the fortune or misfortune to be involved in various inquiries, including representing the Department for Education in the Independent Inquiry to Child Sexual Abuse, and now representing the Department for Education in the same capacity in the COVID inquiry. So Galina and I also share a room. So we have had many an exciting discussion, shall we say, over our salads at lunchtime about these various issues. So my first topic today is challenging Section 21 notices. Now, Section 21 of the Inquiries Act basically provides the legal basis by which the chair of the inquiry can issue a notice compelling individuals, organisations, or an other thing with a legal personality to provide either evidence, documents, or any other thing in their custody and control for inspection, examination, or testing. And for example, during the Grenfell inquiry, there would have been quite a lot of keeping things for inspection, examination, and testing, for example, the relevant cladding and things like that, or to provide either written or oral evidence to the inquiry. So if you are asked to produce such, or if somebody says to you, an inquiry says, I'm going to issue a Section 21 notice, that is what it is. And it should be a formal notice, because breach of it is the equivalent. It's in effect, you have to attach what we in civil procedure would call, it's almost like a penal notice to it, saying, if you do not do this within a certain period of time, we may issue proceedings for contempt of court, or it may well be a criminal offence. So it is the more draconian of options that an inquiry can issue, but often for your clients, it is absolutely necessary to have a Section 21 notice, in particular if there are issues of confidentiality, or if there are issues of sensitivity in the material that you're being asked to share. It provides the relevant basis upon which the data protection exemptions and GDPR can be complied with, because you're being issued by a notice by the equivalent of a court, in effect. So if it drops through your door, first thing to do is check what the consequences are of not complying, and that they've put that information in there. The notice is not valid unless that's been done. And secondly, you might want to think about challenging the notice. Next slide, please. Now, in the previous one of these seminars, we spoke about what to do if you think that there's information that has been subject to Section 21 that is privileged, that's confidential, that's subject to public interest immunity, that's contrary to the right against self-incrimination, and there are a number of slides which set out those issues. What I wanted to talk about today were the other grounds upon which you could object, which are the more practical grounds. So often you will be sent a notice which says, we want all the documents about everything you've ever done, ever, for the past 35 years in 4 weeks, please. And you're sitting there thinking, okay, well, we've got 59 Iron Mountain storage boxes sitting somewhere in Pendle. We've got 15 different branch offices all around the country. We've got paper documents, we've got email documents. There's absolutely no way we're going to be able to do this. So the first thing you do, and you're perfectly entitled under the Section 21 to issue a notice objecting, and then the inquiry chair has to make a decision one way or another what it's going to do, to say timing. So the inquiry will nearly always, hopefully, the inquiry will have phoned you up and said, look, we're thinking about doing this. How long do you think you're going to need to get this, that, and the other document? However, the inquiries, my experience of the inquiry, having been both the person who's issuing these notices and also the person who's responding to them, is the inquiry tends to be quite optimistic about how long it's going to take to get that information. And most of the people who are in receipt of needing to find the information have to then say, it's going to take us quite some time to find that. So that's the first issue, is timing. And so therefore, I would say probably, like all these things, the first thing you do is pick up the phone or email the solicitor to the inquiry or your contact at the inquiry to say, look, this is just dropped on our doormat. We've got some worries. Whether you're legally represented or not, that's a good thing to do. And then to discuss what a realistic timescale is, because then the Section 21 notice can be varied along those lines and or even revoked if you say, well, which comes on to the next bit, which is we're not sure whether we've got the relevant evidence, and or we think somebody else will be better placed to provide us with that evidence. So, for example, if you're dealing with something where there have been criminal proceedings, it may well be that the police don't have any records, but the CPS do, for example. So they may well say everything went over to the CPS when the decision was made to charge, and we haven't kept any of the documents, particularly for matters. Don't forget that most public sector organisations and private sector organisations did a massive overhaul when GDPR came in. And therefore, if you're looking at anything pre-2018, you are going to have to find out what they threw away in 2018 as your start point. You've also, in a lot of cases, particularly if you're a large organisation, will actually have no idea whether or not you've got some of the relevant evidence or information. So again, it's about going back and trying to find out. Now, large organisations and small organisations should have record keeping policies and also should have record retention records to say under GDPR what they've got and where it is. But my experience again has been that they're not always as thorough as they are likely to need to be for you to actually find out whether you've got those bits or whether you don't have those bits. The other thing that I would say at this point is people's email inboxes. These days, practically everything is done electronically, and the first thing you should be looking at and asking for on a very practical basis, if you're served with a Section 21 notice in respect of evidence, is, do we have everyone's email inbox? What happens when people leave the organisation? Because what always happens is Gillian or whoever it is who's the person who dealt with the issue has subsequently left the organisation. What happens to the email inbox there? Can you get access to it? Because in a number of organisations where I've been involved with, email inboxes when people leave the organisation basically get shut down, and therefore it can be quite difficult. So you need to kind of go and speak to the IT person and the records person to find out what's going on there. So it's kind of timing. Have you got the information? Is it disproportionate to be asked to provide the quantity or nature of evidence? Under Section 17(3) of the Inquiries Act, the chair must have regard to the need to avoid unnecessary cost. Now, the inquiry will always want as much as you can possibly give it. Sometimes, tactically, you might want to give them absolutely everything. So all 50 million documents you may well have, but the practical reality is that you again are likely to have to enter into some kind of negotiation with the inquiry to say, for example, if I am a government department and I'm being asked to provide all records about a series of policies over the past 25 years, I am likely to be able to find the current policy quite quickly. I am unlikely, or it might be very difficult for me to trace through what the policy may have been some 20 or 30 years ago. And therefore, I may want to say, do you really need it? It's going to cost us months. And also just the sheer cost of trying to gather information together. As we all know, the most expensive part of any litigation process is disclosure. It is also likely to be the most expensive part for you as an organisation of any inquiry, is getting the documents, finding them, collating them, looking at them is likely to be a reasonably expensive process for you, and certainly quite people heavy, because you actually, even with new AI tools, question mark, that works if you've got your own AI systems which can scan through things, but you can't actually, a lot of this documentation you wouldn't be able to upload to ChatGPT or the other open AI systems, as that would involve probably breaching your confidence as an organization. It still requires, at the very least, even if you're going to use AI to find the stuff, a check by a human being as to whether or not AI has got it right or not. So proportionality, and obviously the larger the organization and the more involved you are in the process, the less likely you are to be given slack. On a number of occasions, if you're a small organization and you can say, look, it's going to take 4 people 6 months to find this stuff, can we just give you something, a broad overview, and you can come back to us? And there's only 5 of us in the organization, so we would be doing nothing else. The likelihood is that the inquiry will take a pragmatic line. If the inquiry asks for evidence outside the terms of reference, you can say, well, no, that's not part and parcel of the terms of reference. You don't have the vires to ask for that information, because it's not relevant, and or you've got no jurisdiction to require us to do so. I mean, the reality is that the terms of reference in most public inquiries are pretty wide, so it would only be in very specific situations where you felt that people were undertaking, in effect, a fishing expedition, that you would be looking to close that down. And last but by no means least, the evidence isn't relevant. Now, very often, in fact, in my experience, always, you as an organisation which is usually intimately involved in the policy issues which are being raised, or in the factual issues which are being raised, are going to know a lot more about what's relevant and what's not than the inquiry are, particularly at the start of the process. So the inquiry might ask you for quite a lot of information that that is never going to be relevant. That data is never going to tell you what you want it to tell you. So again, it's about kind of going back and looking at that. Next slide, please. So you have to make a formal application to the chair, and the notice can be revoked. Sometimes there may well even be a hearing or written submissions. Usually it's done by way of written submissions. Very rarely there may well be an oral hearing about whether or not Section 21 would be revoked. The most obvious example of that might be if you were dealing with something which directly impacted on a significant issue to do with the hearing, to do with the inquiry, and other core participants, the chair might consider, out of a matter of fairness, should know about that. Next slide, please. The only other exception I wanted to talk about briefly is damage to the economy. Now, I've never actually known this be issued, but if you're dealing with kind of something which might involve the Treasury, they may well, or the FCA or the Bank of England, this is likely to be something that they may well pull out of the bag under Section 23. And I think as well, what you have to think about is that the Inquiries Act 2005 happened not that long after 2 quite big financial scandals, one of which was BCCI and the other one of which was the Three Rivers saga of litigation. And therefore, issues to do with financial misconduct were probably quite high in the minds of the legislators. Subsequent to that, I can't actually think that there have been any public inquiries, bar possibly the Post Office inquiry, which have focused, and the inquiry into the Cayman Islands and the Turks and Caicos, which have largely focused upon matters which might impact damage to the economy. So there is a power in which you can say this will damage the economy. But I mean, I would envisage that those applications would be full and would be few and far between. Next slide, please. The other area where you can try and push back on requests asked would be to say, okay, we're going to give you this information, but we're going to make it subject to a restriction notice, or we would like you as an inquiry to issue a restriction notice. And there are a multitude of ways. Every inquiry will have a restriction notice set of principles and set of guidance. Every inquiry will be likely to apply some kinds of restrictions. Some of them are routine, data protection. So, for example, in all public inquiries, you're asked to look at your witness statement if you give evidence, and the signature on your witness statement is always covered over for data protection reasons, even when it comes up on the screen. So there are those sorts of basic things that the inquiry will do as a matter of routine. However, you may well say, okay, and this is particularly the case in two circumstances, well, three really. One, national security, which really only applies to central government departments, people like the MOD. Two, commercial sensitivity, which can apply to anyone. And three, naming individuals or jigsaw identification of individuals or organisation which will harm them. So what you have to realise is when you apply for there to be a restriction notice, and although the inquiry can do it of its own volition, you could say, I am only giving you this if you agree to give us a restriction notice which covers X and Y and Z. You can only have a restriction notice if it's required by law or to fulfill the terms of reference. So, for example, legally privileged material subject to public interest immunity would all be subject to a blanket restriction notice. And what you also need to know about Section 19 and restriction notices is that it only relates to matters which go into the public domain. So it may well be that there are matters which are the subject of commercial sensitivity which get sent to the inquiry, but then don't get sent either to other core participants or don't get put into the public domain. So you have to think about, if you want to make such an application, do I even want the inquiry to see it? And if I don't, why don't I? What's my basis for saying no? Am I happy for the inquiry to see it, but not for core participants to see it? If so, why? Or I'm happy for the inquiry and core participants to see it, but I don't think it should be published because of various reasons. Again, why? So you have to think about those three things when you're thinking about whether or not you should apply to a restriction notice. And the restriction notice can be made at any time. So very frequently, especially if there's cases where there's been very, very large quantities of disclosure, it's only when it approaches the time for a document to go up on a screen in a hearing that either you or the inquiry thinks, oh my God, we might need to issue a restriction notice about this. Next slide, please. So considerations under Section 19, this is what the chair has to think about it. Would the restriction inhibit the allaying of public concern? Would it cause harm or damage? And that's in particular in respect of individuals, very often in respect of if either naming them would cause them significant harm or any harm, and harm includes psychological damage. And there's been a number of cases in which restriction orders are made where people have got recognised psychological disorders or have suffered from psychiatric as well as physical injuries, which means that it would not be appropriate to name them. For example, conditions as to confidentiality. So particularly in respect of journalists, they may well want to be confidential, or they may well say, I'm happy to give you my sources, or I'm not happy to give you my sources, but they need to be subject to confidentiality because we can't have other core participants knowing about that. The extent to which imposing a restriction would be likely to cause delay or impair the efficiency of the public inquiry. So that's either imposing it or not imposing it, because often there are ways around it, but it would take you 6 months, 9 months, a year to do that, and you don't have time. And again, pick up the phone. And harm or damage includes death or injury, national security, economic interest of the UK, or commercially sensitive information. I would probably say that A and D are the ones which are most commonly relied on. C is rarely relied on. B is really only relied on when you're dealing with those kinds of issues to do with policing. So undercover policing, lots of things. The Afghan inquiry, lots of things, al-Swady, anything which involves, the state behaving badly in a policing or in a national security or in an armed forces context is you're likely to have a lot of national security issues. You're unlikely to have that in other areas. Although, even, for example, within the COVID inquiry, there will be some issues which will be subject to national security. So even in those sorts of things, you have to think about that. Next slide, please. Obvious examples where you might need to use Section 19 or ask for a restriction order before handing documents over, and or say we're only going to hand it over if you agree to do this at the same time. Medical records or any other kind of personal records, social services records, medical information, etc., etc. Information which is going to lead someone subject to an anonymity order in Crown proceedings, civil proceedings, family proceedings to be named. So that would be children, those who've reported sexual offending, where there's other kinds of offending such as forced marriage, FGM, and national security, where you might need it to meet someone's protected characteristic under the Equality Act. Don't forget the inquiry is providing a public service, and therefore would have to act if there were issues to do with someone's disability or someone's other protected characteristic, where you might need a restriction order. If there's commercial information, pricing of contracts, tenders, those kinds of things, and national security. But again, the advantage of a public inquiry is there can be closed material procedure sessions, and there can be closed sessions, and there are quite frequently closed sessions in issues where that takes place. Next slide, please. What happens if you don't comply with Section 21? Well, fundamentally, you can either be prosecuted or you can there can be an application for contempt of court. So there is a prosecution in the magistrates' court of failing without a reasonable excuse. In order to institute such proceedings, the chair needs the consent of the Director of Public Prosecutions, and it's likely, I would imagine, that the CPS would take over the prosecution at that stage. I cannot find any evidence of anyone actually being prosecuted under this offence, but it may well be that that's the case and I just haven't found it. So you can get up to 51 weeks in prison or a fine of up to £1,000. So that's the criminal offence. I can't find any evidence that that's ever been used. However, next slide, please. Section 36 of the Public Inquiries Act provides an alternative, which is if somebody either breaches a notice under Section 19, so that's a restriction order, i.e. names someone, does something, provides some information which they shouldn't, or fails to provide the material under Section 21, or threatens to do so, then the chair of the inquiry can send the matter to the High Court for them, in effect, to deal with the issue of contempt of court and to use the Contempt of Court Act 1981 and therefore CPR 81 and all the procedural issues that come with that and all the procedural safeguards. So if you were the inquiry, you would be issuing an application, in effect, pursuant to CPR 81, taking into account all the relevant information, not forgetting that there are a fair number of very detailed procedures that you have to undertake. And remembering, of course, any breach has to be proven to the criminal standard. The individuals have the right to legal aid, need for clarity in drafting the application, what's been breached, when, etc. And then you can if, of course, there is then a trial, your organisation or an individual from your organisation could be found in contempt of court. And don't forget that various directors, companies, all those sorts of individuals can obviously, it's not just individuals against whom contempt of court proceedings can be brought. Anyone with a legal personality can be potentially subject to contempt of court proceedings. Next slide, please. Now, one specific exemption I wanted to reach, just because this tends to be circumstances where there tend to be standoffs, which is disclosure of information from journalists or from information who've been given tip-offs from either anonymous sources or from sources they don't wish to name. So under Section 10 of the Contempt of Court Act 1991, a court may not require someone to disclose a source of information contained in a publication for which he is responsible, unless it's established to the satisfaction of the court that such is necessary in the interests of justice, national security, or the prevention of disorder or crime. So the court will undertake that. This is mainly something which is of relevance to newspapers, legal bloggers, people who may retain that. And the inquiry and the court would have to look at Article 10 and the HRA 1998 and freedom of expression when determining the issues and determining whether or not the Section 21 notice should be enforced. So the last occasion upon which such a threat was made was Johnny Mercer in the Afghan inquiry, which is currently ongoing. He was an MP. He's always been very involved in veterans. I think he might even have been a minister at that particular point in time. And he says he was tipped off by people, but he wasn't going to tell the inquiry what it was. Now, it would appear that a compromise was reached, but I think he was threatened with either criminal proceedings or contempt of court in a very open and public way by Lord Justice Haddon Cave, who is the chair of that particular inquiry. Now, a case in which somebody was ordered to provide the information is re Ian Paisley Jr. Now, that's to do with the Billy Wright inquiry, which I believe is somebody who was murdered by loyalist paramilitaries during the course of the Troubles. Ian Paisley Jr. had said, I had been given various information by a prison officer, which was relevant to the issues to do with how Mr. Wright came to die. But I am not going to tell you who that prison officer was or the nature of the information. And I've given you the citation there. It's a very useful summary of the legislative background. And as a result of which, the court found that Ian Paisley had to, and I've unhappily spelt his name incorrectly in the second bit, but not the first bit, that he had to hand the information over in 17 days. I don't think he actually did so. I can't quite find out whether or not he ended up going to prison for a short period of time for not doing so. But certainly if you're representing newspapers, if you're representing things where there are confidential sources who've tipped you off about various things, you are going to need to think about this and discuss this with the inquiry and recognise that ultimately, if you stick to your guns, this might be what happens. I would say that I think it's very rare for inquiries to ever threaten contempt of court proceedings. Most of the time, I would say 99% of the time, everybody does what they're asked. And even if you're dealing with journalistic sources, certainly if you're dealing with like the BBC or Channel 4 News or the national newspapers, there will be a discussion about that. Google says that Ian Paisley was fined but avoided prison. Thank you very much, Galina. See, it just shows that I was just looking on Bailey and things like that, not just doing the Google. Next slide, please. Warning letters. So the next thing I'm going to talk about is the other process, which is under Section 13 of the Inquiry Rules 2006, if you have been subject to criticism during the inquiry procedure, or criticism may be inferred from evidence given during proceedings, then you should be issued with a letter by the inquiry which says what the criticism is and the statement of facts and the evidence upon which that information is reached. So and you must not include, the inquiry is not allowed to include either explicit or significant criticism. Now, neither explicit nor or significant is in effect identified in the Act. It's not interpreted, so it's got to be interpreted using English language. Significant would, I'm thinking about the way we use it in the Equality Act, more than minor or trivial. Explicit must be, explicit rather than inferred if you think about X and Y for a chain of logic. So they have to send you a warning letter. Next slide, please. Different inquiries adopt different processes in respect of warning letters. Some will send you the entire report. Some will send you chapters of the report. Some will just send you 2 sentences, for which it's often quite difficult to divine what it is they're criticising and why. And they will also send you the evidence. And again, sometimes that's hundreds of documents that you need to go through. At other times, it's just a couple of pages of documents. So you are under no obligation to respond to the warning letter. You don't have to. Some thoughts, if you do decide to respond, which is 1, do you provide further new evidence? Now, obviously, that is not evidence which is already in the public domain. It's not evidence which the inquiry already has. There may well be questions about, well, why has this evidence only just appeared? But in some circumstances, it may well be justified to say, "Oh, hold on a minute. Before you criticise me, could you look at this report, and this report, which has been commissioned subsequent to the hearing you had about this, which in fact says X and Y and Z, and it would be unfair for you not to consider it prior to the production of a report." Now, the inquiry will hate you for doing that, but in the appropriate case, my view is it is appropriate. The other issue, the other thing to think about is, can you go back through the evidence and find things which contradict the basis upon which the evidence is relied upon? So they may well have relied upon Joe Bloggs giving evidence, but actually you know that Anthea Turner, Grant Shapps, Alan Partridge, and I don't know, the Queen have given evidence which directly contradicts that. That's like a quite eclectic mix of people. So you you could, you can. The reality is that the inquiry will usually give you 3 or 4 weeks to do this process. So your ability to really scour through things, unless you've got 50 paralegals working for you, is going to be quite limited. But in some circumstances, when it's very important to your client, you may well need to scour through. And my advice to you is, if you think you're likely to be subject to explicit criticism, don't wait until you get the warning letter to start undertaking this process. If you think you're going to have to go back through a lot of documents. The other issue to deal with is, can you rebut what's said to say, I don't think that this conclusion can be inferred from the evidence. I don't think the evidence supports this. I don't think you've got any evidence about this, in which case you should obviously say that to the inquiry, or this is not factually accurate, this isn't fair. One of the questions that I'm often asked is, well, it hadn't been put to me at the inquiry hearing, therefore you can't criticise me about it. Now, these aren't civil proceedings. It is best that if there are major and explicit criticisms, that they are put to the witness in oral evidence. However, there will always be things which come up. And my view is, obviously subject to, everything is fact and context dependent in this circumstance, is that it would be quite difficult as a matter of right to say, this hasn't been put to me at a hearing, therefore you cannot criticise me about it. Largely because public hearings tend to be quite iterative processes. What happens if, for example, the person who comes the day after you does criticise you? Does that mean you've got to go back into the box to be subject to that criticism? You can imagine things would become unwieldy and unmanageable. But there might be some circumstances in which you would say, actually, this is such a central point, I should have been given an opportunity to do that. And therefore, before you criticise me, I either want you to take account this new material, or I want you to have another hearing so that I can say this matter in public. The inquiry will like you even less for saying that. Next slide, please. The other thing I should say about warning letters is, other than legal representatives, you can only disclose the warning letter to those whom the inquiry has approved. So if you're working in a large organisation, you need to get in touch with the inquiry or find out from them roughly when it's coming, and put a proper list together of, these are the people we absolutely need to see this, because otherwise you may well be stuck with only a very small number of people. If you're a government department, a local authority, a large private sector organisation, you're likely to you may well need a number of people to respond effectively to the warning letter. So you need to ask for a waiver. Don't forget that even receiving a warning letter, you can't even tell people that you've received a warning letter until the report is signed. And you can be sued for breach of confidence. And the inquiries, all inquiries, take the duties of confidentiality of core participants and recognise legal representatives and those who receive warning letters extremely seriously. So don't think they won't do anything about it, because they will. So that is the end of my little missive. I hope it was quite helpful. I'm now going to pass over to Galina, who's going to tell you all about judicially reviewing the inquiries and how you can do it successfully or maybe unsuccessfully. Thank you. Galina, you're on mute.
Okay, I've discovered I can temporarily unmute myself by holding down the taskbar, but I can't currently find the controls on Zoom, which is a bit incompetent of me. So just give me 30 seconds and I'm going to try and work. Okay, turns out I had to change what the main screen was. Right, sorry about that, everyone. Thank you very much, Fiona, for that introduction. In what remains of this session, I'm just going to touch quite quickly on some issues, as she says, around judicial reviews of inquiries. I have had quite a long career as a public lawyer, and a long time ago, that career started with a couple of judicial reviews, one of which led to the Shipman inquiry being established. And the other, involving the same team, rather less successfully tried to get an inquiry into the foot and mouth outbreak. All of that predated the 2005 Act. And this seminar, of course, is about challenges to actually existing inquiries, not whether they should exist at all, or what their terms of reference should be. And what I'm going to cover, could someone just pop in the chat whether these slides are up? Because I can't see them now on my screen. No. Yes, they are. Thank you, Fiona. And if I press that, what slide is now up? Sorry, I don't quite understand what's happened to the technology here. Right, so when you can judicially review is on the screen. So what, yeah, as that slide says, there are a number of possible targets for judicial review here. There are procedural decisions that the inquiry makes as it goes along. Those overlap with, but are a slightly separate category, I think, to the exercise of specific powers that the inquiry has to give notices under Section 21, for example, make orders under Section 19, as Fiona's been discussing. And then, of course, you have the report itself. And finally, I'm just going to give you a few words on what happens when the recommendations are made, the inquiry report is out there, and whether there might be any potential scope for challenge there. So, do you know what? I'm going to say next slide, please, and ask Hilary to be in charge. Hoping that she is still there. I really don't understand what is. Ah, okay. Put it back, not to worry. Okay, so I've just put up there on the screen the Section 38 of the Inquiries Act, which of course provides a very tight time limit of 14 days from the date on which the applicant becomes aware of any decision to bring a claim for judicial review. So not the normal time limit, of course, in judicial review, you have to act promptly, but you can usually bank on having 3 months. In the context of a judicial review of any decision made either by a minister in relation to an inquiry, or what we're really talking about, a member of an inquiry panel, you only have 14 days from the date on which you become aware of that decision. The other slightly interesting thing, I suppose, about Section 38 is it does indicate that you can bring these judicial reviews, and of course it excludes from the 14-day time limit the contents of the report of the inquiry, or any decision of which the applicant could not become aware until the publication of the report. So again, it's contemplating that those are matters that might be judicially reviewable, and as I said, the ordinary time limit applies in those cases. Hilary, can I have the next slide, please? Thank you. So starting then with procedural decisions, there's obviously an overarching obligation of fairness, and Fiona touched on this in the context of Section 17 of the 2005 Act. That does refer to proportionality, but it does also provide that everything that the inquiry does has to be has to be based on principles of fairness. And anyone who's familiar with what I do when I'm not acting in public inquiries, which is some fairly high-profile judicial reviews, will know that the questions of fairness ultimately are generally said to be for the court to judge. So it's not a rationality test. The court itself will assess what is fair and whether a decision has breached the principle of fairness. Having said that, it's quite interesting to see how the court has approached that in the context of judicial reviews of inquiries. And I've put up there, first of all, probably the now second most well-known judicial review of an inquiry, the Savile case, which was about the Bloody Sunday inquiry and the decision there to grant anonymity to soldiers whose lives might otherwise be at risk as a result of giving evidence. In that case, the court held that the only decision that was possibly open to the inquiry, which wasn't the decision the inquiry had reached, was to grant anonymity to those soldiers. But then you have the Leveson case, which of course was a bit less stark. The challenge there was to a decision to grant to journalists anonymity if they gave evidence, and that was challenged by news organisations whose practices might have been, they were concerned about the journalists exposing their practices. And the court deciding that challenge recognised that it was a question of fairness, so it's ultimately for the court to decide whether it would be unjust to grant anonymity, but said in doing so, the court must recognise that the chair is in a far better position to assess and balance the degree of prejudice which may be caused to different parties because of the chair's infinitely greater knowledge of the details and feel for where justice lies. So what was said there was that the court would only interfere if it was satisfied, notwithstanding the chair's considerable advantage, that he was wrong. And in that case, the challenge was dismissed. And another thing that the court said towards the end of the judgment was that judicial review is a means of correcting unlawfulness. It's not for the court to micromanage, as they put it, the conduct of the inquiry by the chairman. And there are other cases where that kind of approach comes across, and I've put up there the EA case, which is about the grant of core participant status. Two things to note about that case. Firstly, the actual decision there was that the challenge was brought out of time, an attempt to argue that the chair's refusal to reconsider the original reasoned decision to refuse core participant status, that was the operative decision and started the 14 days running, was rejected. And there was a real emphasis on the importance of avoiding delay in cases of challenges to public inquiries, both in general and in that one in particular, because of the obvious distress that would be caused to survivors and families if there was any delay, and also the importance of learning the lessons as quickly as possible. But the court also addressed the substantive question in refusing permission, but thought about the substantive question and decided it was not arguable that the survivors of the Manchester Arena attack, who were challenging a decision not to grant them core participant status, it was held that it was not arguable that they were entitled to that status because the inquiry had been established to investigate the circumstances of the killings and was not designed to cover every aspect of the state's investigative obligations under Articles 2 and 3. And in any event, they said on the facts of that case, an inquiry involving the survivors wasn't necessary to discharge any obligation that was owed to them by the state. So again, quite a hard line. We're giving the chair a lot of latitude here to think about their own procedural decisions. That is not to say, however, that the court won't intervene. And I've put up on the slide the last case, the Greater Glasgow Health Board case, which is a fairly recent Scottish case, where the Greater Glasgow Health Board, which was a core participant in that inquiry, had applied for the admission of an expert report that it had commissioned, and it wanted the authors of that report to give oral evidence. Other core participants resisted. The chair held a hearing and decided not to admit the report. And really, that's the kind of thing you might well think is within the scope of what was described in the Leveson case as micromanagement. The chair refused the application on the basis that this report was an advocacy document prepared for a single court participant and might undermine the inquisitorial nature of the inquiry. The court just disagreed, said as a charitable interpretation might be that there was an issue of principle as to whether it would change the nature of the hearing from inquisitorial to adversarial, but ultimately the court just took a different view on fairness. So I think two things to take away there. Firstly, really worth having a look at that case if you have a procedural decision that you're considering judicially reviewing. But secondly, that it is very hard to predict in this space when a court is going to take the view that it can determine fairness for itself, as opposed to taking a kind of rationality-based approach to the decisions of the chair. If I cover the next slide, please, Hilary. Just very quickly on the different kinds of orders, notices under the 2005 Act. Fiona obviously covered in some detail the substance of sections 19 and 21. Just to flag a couple of cases that there have been where there's been judicial review of decisions taken under those sections. The BBC and the Scottish Child Abuse Inquiry case, that was a case in which the chair of the inquiry had issued a section 19 order in relation to a claim that had been made against the inquiry by a former counsel to that inquiry in the employment tribunal. And the BBC challenged that decision, said, well, that's not in the interest of open justice, is it? And the court held that that claim in the employment tribunal was actually nothing to do with the inquiry's terms of reference. So there was no power to make the restriction order at all under section 19. And if you wanted to that material to be kept out of the public domain, you'd have to make the appropriate application in the employment tribunal proceedings themselves. Just to contrast that, although a case where the application for judicial review was refused, the Ezell Rodney case, the inquiry chair had refused to make a restriction order in relation to the footage of the events leading up to the death of Ezell Rodney. His mother, who was obviously a core participant in that inquiry, wanted to see it. The chair had decided that she should be allowed to see it. And in circumstances where effectively the court said, well, the chairs asked themselves the right questions and thought about all the appropriate things, that decision was upheld. I've then just flagged the Cabinet Office case, so probably the most famous case now in this field. Obviously, it was a very high-profile case a year or so ago. And in that case, the court upheld the right of the chair of the COVID inquiry to ask for material that might go wider than would be strictly necessary to determine issues within her terms of reference, and held that she was entitled within reason to make that assessment herself. And I mean, effectively, and the undercurrent is that the core participants couldn't necessarily be trusted to do it themselves. And when Fiona talks about the pain of working through hundreds and hundreds of pages of disclosure and that being a very person-heavy endeavour, we are all feeling that particular pain at the moment. I know there are people in the audience who certainly are feeling it. So finally then, in terms of just the cases that are out there reported on challenges to decisions under the 2005 Act, a recent reported decision under section 40, which was about the refusal of funding to the traveller movement. Again, a decision made by the chair of the COVID-19 inquiry. It was actually a refusal of permission to apply for judicial review, and the court in that context took the view that it was a rationality test that applied to the chair's interpretation of whether the term substantial, which was the operative term in the test that she was applying in that context, that again, subject to rationality, that was a matter of interpretation for her, and didn't really descend into questions of fairness or otherwise of that decision itself. Permission to apply for judicial review was refused. Could I have the next slide, please, Hilary? Thank you. So just very, very quickly on whether you might judicially review the report of an inquiry. Again, Fiona covered the warning letter process, and probably the most fertile ground for a challenge to a report once it exists would be there been a failure to follow that process. I'm not aware of any challenges, certainly that have made it to court and been reported. Note, of course, that under Section 25 of the 2005 Act, there's a duty to publish the report, so it's going to be a pretty hard sell to try and stop it being published in the form that the chair wants to publish it in. There are, and I've flagged the possibility of injunctions against publication. There are a number of cases in other contexts, for example, Ofsted reports, that might be worth looking at if you think there's anything really unfair to your client in the report and you've seen it under the Section 25 Rule 17 process, whereby the draft is released to court participants before publication. But it does seem to me that if the warning letter process has been properly followed, it's likely to be quite difficult to get off the ground. One other thing I thought perhaps worth flagging here is under Section 2 of the 2005 Act, the inquiry doesn't have the power to rule on, has no power to determine civil or criminal liability. So insofar as it purports to do that, you might work up a case, but it does provide that it's not to be inhibited in the discharge of its functions by any likelihood that such liability will be inferred. So it would have to be an inquiry that very unusually didn't moderate its language sufficiently to make clear that it wasn't making such a finding. Okay, finally, and have the last slide, please, Hilary, and I'm conscious of the time, so I'm just going to very, very briefly touch on what happens once the report is released, because this is something that's quite a hot topic currently. There's been a report of the House of Lords Statutory Inquiries Committee called Public Inquiries and Enhancing Public Trust, and the government has responded to that, which, amongst other things, raises this concern, which has been bubbling under and raised in a number of other places, about the lack of any kind of coordinated approach to responding to inquiries, and in particular monitoring the recommendations. The government does have a policy that it will respond within 2 months to recommendations that are made. Whether or not you could challenge a failure to do so is, I think, questionable, whether that is the kind of policy that you're entitled to rely upon and enforce as a claimant. But it is, as I said, a well-recognised lacuna that there's no means to ensure under the statute, even monitor whether recommendations are acted on. 2 points just to close on. And firstly, in the COVID inquiry, we know the previous government accepted most of the recommendations of Module 1 of that inquiry's report. It now feels like every time you go along to the hearing centre, there's someone saying to the chair, you should be calling Pat McFadden, the Minister for the Cabinet Office, to explain what's going on now and how those recommendations are being acted on. But as of yet, no indication that's going to happen. And the other thing is that there are things that chairs can do. So, for example, the Independent Inquiry into Child Sex Abuse had a process for, while it was still constituted, on its website, a publicised process saying that if you don't respond to our recommendations, we're going to send Rule 9s and potentially Section 21s to require organisations to respond properly. I'm not sure if that was ever done, but Fiona might be able to help us there. I would very much recommend a read of that House of Lords Statutory Inquiries Committee report. In the meantime, that having been a very quick canter through some thoughts on potential challenges, we're now open to questions for, let's say, 5 minutes, because we started late.
Yeah, thank you very much, Galina. Sorry, I think I just froze briefly there. I'm not sure it ever was used. What some of the other inquiries have been doing, and I'm thinking in particular Sir Brian Langstaff in the infected blood inquiry, is he has not closed the inquiry so that he can hear further evidence about what's going on. And last month he had a further hearing about the compensation scheme which has been set up in order, in effect, to hold the government's feet to the flames if needs be. So that's what's tending to happen these days, because obviously you cannot rely, or at the moment it's only a recommendation. What some chairs of some inquiries are doing is keeping the inquiry open in order to ensure that things are implemented.
Well, the government can shut me down.
Exactly. The government can decide to stop them, but so far that has not happened.
Yeah.
So yeah, I don't think we have any questions. I mean, obviously we have no questions because we've been so comprehensive, or alternatively because everyone's gone to sleep. I hope it's the former and not the latter. I just wanted to say thank you all so much for listening to us so patiently. Thank you, Galina, for what has been a really interesting talk, and in particular, see the trend for an increasing number of judicial reviews over the past few years in this area, albeit most of them not very successful. And we look forward to seeing you and to meeting you either in person or at one of our future seminars. Thank you very much. Good night.
Bye-bye.